Well, good morning, everyone, and welcome to today's Ask a Pro webinar. Today's topic is MedPay and PIP. My name is Ted Traut, and I will be the moderator for today's session. I'm a partner here in the Cleveland, Ohio office for Weltman, and I'm the chair of the Subrogation Practice Group. While our firm manages a national litigation network of attorneys, we do have a 7-state footprint of states where Weltman attorneys practice. Those states include Kentucky, Illinois, Indiana, Michigan, New Jersey, Pennsylvania, and Ohio, in alphabetical order, so I didn't want to slight anyone. So as such, today's presentation will more than likely focus mostly on those states. I'm a licensed attorney in the state of Ohio, but I also act as in-house counsel to our national collections team and our national forwarding network. But that's enough about me. Steve Jobs once said that he doesn't hire smart people to tell them what to do. He hires smart people so that they can tell him what he should do. So in that vein, I'd like you to introduce you to our panel of smart people that like to tell me what to do, although it's not always for a PG audience. So I'll turn it over to Tiffani, and then after you're done, you can send it to Tom and then to Michael.
Sounds good. Good morning, everyone. My name is Tiffani Palmer. I'm a partner in the Detroit, Michigan office. I'm excited that you all are here. This is a topic that I love, especially PIP with being in Michigan. By the way of background, I have an interesting background. I actually used to be a claims adjuster for one of a major carrier. And then also I used to do plaintiff's work. So I used to sue insurance companies. So I like to say I've been on both sides of the V. So, and in addition to that, I just wanted to share with you all that prior to coming to Weltman, I actually had my own practice for a little bit. And so with having my own practice, I was able to deal with a lot of different clients and customers. And so I hope that in my presentation with the clients that are on this webinar today and those that I meet, I am able to relate to a lot of you and come across as approachable. That's my goal. And so with that, I'm going to turn it over to Tom because I'll talk the entire time.
Thanks, Tiff. And hello, everyone. I'm Tom Duquette. I also work out of our Michigan office with Tiffani. I've been at Weltman for just under a year now, and also, like Tiffani, come to the firm with some background in personal injury work and specifically work that focused on first-party no-fault claims. We represented individuals and providers, so I've seen subrogation actions from the flip side of the coin. My practice areas now at the firm include, obviously, subrogation and also consumer collections.
All right, everybody, I'm Mike Chapman, and I took sort of a roundabout way to get here before I figured out what I actually like doing. I was a high school teacher and then went to law school, and I practiced business law, real estate, estate planning, and found it to be ridiculously boring. I went to work for one of Weltman's competitors for about 6 years doing compliance work and subrogation, and I really enjoyed it. But I sort of wanted to know what was out there. So I went to work for a prestigious firm doing insurance defense work, product liability, and commercial litigation for about 15 years. And I always had a few subrogation cases, usually, you know, mid-sized property losses, product liability, and a lot of Carmack trucking claims. And I just sort of came to the realization that what I really like doing is subrogation work. I just really enjoy it. So I'm blessed to be back in subrogation working at Weltman, and I get to do some things that I really enjoy with the law. So I get a case, I get a call opposing counsel and settle the case right away, which you would never do in defense work until you meet certain billables and do discovery and take as many depositions as you can. And then I get to try cases. If I can't settle the case, I get to travel all through Indiana, Kentucky, Ohio, and show up in trial. Tom has a trial later today, in fact. So that's one of the things that I really enjoy about subrogation.
Thanks, panel. Let me roll the slide here. All right, so a couple things before we get started. I just want to go over a few housekeeping items. We want to keep this an interactive session, so please submit your questions to the question button in the control panel. There's a chat, and if you type in your question, we should be able to see it. And we'll try to get to it during the session. The webinar is being recorded. At the conclusion of today's session, we will send you a link with the recording, and a copy of the presentation slides will be sent to you. You'll also get a short survey at the end. And please take that and share your feedback. We greatly appreciate it. That's the best way for us to plan materials for future webinars, is to hear from the audience itself as far as what's important to you and what you would like to hear in the future. So again, please take a few minutes to fill that out. We'd really appreciate it. So the question number one, we're here to talk about PIP and MedPay, and what are these things and what are the key differences? And I'll throw that to Tom to start us off today. Since you're the newbie.
Yeah, PIP and MedPay are both auto insurance coverages. Both types of coverages pay regardless of fault for motor vehicle accidents. And while those are similarities, there's obviously differences with the types of coverage. In most states, they're both optional coverages. However, PIP is required in Michigan and 11 other no-fault states. MedPay, on the other hand, is required in only 2 states. And the true differences in the types of coverages lie in the scope of the coverage. PIP is a much more comprehensive coverage. It goes beyond just paying for traditional medical bills. I practice in Michigan, and I'll use it as an example. In this state, PIP benefits include things like expenses for medical, housing, transportation, food, rehabilitation, guardianship, conservatorship, and even funeral expenses. Also things like work loss, replacement services, and survivor's loss. MedPay, on the other hand, it really only covers your traditional medical expenses. It's set up like that because it's designed to supplement standard liability coverage, complement those policies. It can be obtained in addition to a standard liability coverage. It's obviously the flip side of that coin is that it's less comprehensive than PIP, and it doesn't cover nearly as many additions to traditional medical expenses.
I can probably chime in and state the obvious, but neither one cover property damage. And sometimes that question does come up.
That's a great point.
Yeah, I can tell you the first time I dug into a Michigan claim and saw, what is this personal injury protection? And oh, they're paying for people to come clean their house. And it was very different than medical payments coverage that I was used to in Ohio. So anyway, different animal.
Sure.
Okay, question 2. What states are no-fault states, and how does this affect recovery of PIP, personal injury protection, and MedPay in a subrogation case? Tiffany, what are your thoughts on this question?
Okay, thanks, Ted, and thanks, Tom, for explaining. At least now we know what MedPay and PIP is. So let's talk about the no-fault states. So the traditional no-fault states will be Florida, Hawaii, Kansas, Massachusetts, Michigan, Minnesota, New York, North Dakota, Utah. And then Kentucky, New Jersey, and Pennsylvania are what's called optional no-fault or choice no-fault. So those drivers may choose whether or not they're going to be held to the no-fault system. So for the purpose of this question, let's just kind of do a very brief overview of our no-fault states. So we'll just go in alphabetical order, and we'll start with Florida. So in Florida, it seems to be as complicated as Michigan. There is dispute regarding whether subrogation is available for MedPay. There's some case law and statute that looks like it provides for subrogation rights, but then there's also case law and statutes that contradict it. So that's still in the air in that there's disputes regarding whether MedPay is recoverable. However, when we go to PIP benefits, those are only recoverable as a set-off from any verdict or recovery by the insured. The exception to that is subrogation is allowed if either vehicle that's involved is a commercial vehicle that's not required to carry PIP. So that was the first state that we went through, and everybody is confused. So basically, the long and the short is that you can have a set off for PIP benefits in Florida against the insured recovery, and you are allowed subrogation when it's a commercial vehicle for PIP. So now let's go to Hawaii. Again, things are in limbo in Hawaii, but if you live in Hawaii, do you really care? So I would imagine they do not. So a PIP insurer may be reimbursed, so not subrogated, but reimbursed up to 50% of the amount of the no-fault benefits that were paid, and there are also a duplicate recovery for the third-party benefits. So meaning if the insurer had a recovery for those same no-fault benefits, then the insurer can be reimbursed for what they paid up to 50%. And there's also some requirements not to exceed the statutory limit that's spelled out in Hawaii. And the burden of proving whether it's a duplicate benefit is on the PIP carrier. However, there's a bit of a conflict under a doctrine that's called the covered loss deductible, which means that from the third party or BI recovery, there's a reduction of $5,000, which is meant to cover the no-fault benefits. So then that kind of eats into whether it's a duplicate recovery, but that statute is there, and you are entitled to be reimbursed up to 50%. So that's why I said it's kind of in limbo. There has not been any case law that has resolved that conflict as of today. So then we'll go to Kansas. So as it relates to MedPay, MedPay coverage is not identified, where MedPay coverage is not identified as PIP benefits in the policy, no subrogation for MedPay benefits are allowed in Kansas. So it has to be identified in the policy as a PIP benefit in order for MedPay itself to be recoverable. As it relates to PIP itself, the carrier can subrogate for PIP benefits which replace economic damages without limitation, and can subrogate for PIP benefits that replace non-economic damages once $2,000 threshold is met. And that's just a requirement for Kansas. If PIP benefits are paid as a substitute for wage loss or medical benefits, subrogation can be recovered regardless of the amount and without the no-fault threshold. So if it's wage loss or medical benefits that are paid, the recovery can be regardless of the amount without the no-fault threshold, which is $2,000. And then we'll briefly go over Massachusetts. There's no MedPay reimbursement. Well, PIP, the carrier can recover PIP benefits and any expenses it incurs on the account, such as payments, net benefits, and cost of processing the claim. And that's important to remember that sometimes our clients don't always send us over the supports to show how much it costs to actually adjust the claim. In Massachusetts, that's permitted. So just keep that in mind when you're seeing those referrals, or if you're looking for counsel such as Weltman to recover in that state. Subrogation is allowed regardless of whether the insured crosses the tort threshold or files a BI claim. And the tortfeasor's liability carrier has to pay up to its policy limits. So if you have a subrogation claim in Massachusetts, then you can move forward regardless if the BI threshold is met, and that's a statutory threshold for that state. But the tortfeasor's liability carrier has to pay up to the policy limits. So you have to exhaust, those policy limits have to be paid in order for the carrier to pursue that subrogation right. Then we'll go to Michigan. So I'm definitely going to be brief on Michigan. We're talking about Michigan. Michigan is crazy. Everybody says that. So Michigan as far as MedPay, you don't have MedPay for motor vehicle accident, but you will have MedPay if it's a motorcycle. PIP benefits is, what is here in Michigan. As it relates to what's recoverable, subrogation is typically confined to uninsured motorist action, an intentional action, or a or out-of-state accident. So if you have two PIP or two Michigan residents with the PIP policies, then when they're involved in an out-of-state accident, then it's recoverable. So you can subrogate. There are times where you can also subrogate as a result of a priority dispute as well. Some insurance carrier is in a higher priority as you. But again, I don't want to confuse anybody with MedPay and PIP in Michigan, but that's generally, just remember that if you have an uninsured person, if it's intentional or it's an out-of-state accident, then you have subrogation rights. Other than that, you do not. So for Minnesota, subrogation is allowed if it's under the policy, if it's specified under the policy. As it relates to PIP, subrogation against the tortfeasor is allowed only if the claim is based on negligence in maintenance or use of the motor vehicle, intentional tort, strict or statutory liability, or negligence other than the use of operation of a motor vehicle. So basically, we don't have a motor vehicle accident, right? So you can have subrogation if there is, maybe there's work being done to the vehicle or something like that. It would have to be something that's not a traditional motor vehicle accident for you to be able to recover PIP in Minnesota. And then we have New York. MedPay benefits are usually in the form of PIP type benefits, where MedPay is paid, subrogation is prohibited in settlements and in verdicts. For just straight PIP, no subrogation for first party basic PIP benefits, with a few exceptions. And then these states have a lot of different exceptions to them, and I know I've alluded to some, and I haven't really spelled them out because this is obviously only an hour presentation. I won't be able to go over those, but if you have questions, you can not only put them in the comment box, but you can also send us an email if you want more details on it. But I just want to give you just a very basic overview. And
hold on, I'm going to interrupt you just a second so you can get a breath. So
yeah.
I made a comment earlier about I hire smart people. I think this is a good example. I didn't realize you were going to this level of detail. I'm impressed, but you go, girl. I want to give you a breath and get, but this is awesome. Thank you.
No problem at all. And I just want to make sure that, our listeners, just have a general broad understanding. And, obviously we can't cover everything in this presentation, but the hope is that, if you have questions, you can obviously reach out to us, and we love to talk about this. We love to talk about MedPay. We love to talk about PIP. So with that, I'm actually going to—
We're a lot of fun at parties, right?
Yes, we are. We are lots of fun at parties. So with that, I am actually going to actually hand it back over to Ted, and let's move on to the next question.
All right, great.
I can comment on Indiana and Ohio and Kentucky. Anybody cares?
Yes, go ahead, Mike.
Well, I don't like no fault. So no fault just doesn't make any sense unless you're in that state. But Indiana and Ohio are at fault states, which means the tortfeasor's liable and you can just sue them. I like that. Kentucky, as mentioned with Pennsylvania, is a mix, but Kentucky has some weird rules where the first $1,000 is beyond recovery, except for certain circumstances. And Kentucky's weird because if the tortfeasor is uninsured, you can sue that person, but if the tortfeasor is insured, you can only sue the carrier. So it gets it anyway. At fault or no fault states are just ridiculously complicated. So I just wanted to throw that in there. I like no fault or at fault. I'm confused. Go ahead, Ted. Sorry.
Sure, no problem. So What are anti-subrogation laws and what states have those types of provisions? And we'll go with Mike.
So the idea generally is that subrogation is equitable in nature. So an insurance company standing in the shoes of its insured really shouldn't be able to sue its own insured. And some states, Arizona, Connecticut, Kansas, Missouri, New York, New Jersey, North Carolina, and Virginia, and Georgia, for the most part, they just don't allow subrogation. They don't allow reimbursement. They don't allow liens, even if the plan language says otherwise. And that's the gist of the general anti-subrogation rule. There is preemption for federal liens, like for ERISA or Medicare or military benefits. And then some states like Indiana and Kentucky sort of say, you know, an insurer is not really supposed to subrogate against its own insured. And we sometimes see questions whether it's not really a subrogation action, like in Indiana, where you may sue an insured for breach of contract or for recovery of SR 22 payments or bond payments that you pay because you certified the policy to the state. That's really the gist of it. Kentucky's, as much as it's a no-fault state and has all kinds of rules, it's kind of it's in the Wild West with regard to anti-subrogation. So there really isn't any rules, and you make it up as you go. But other states have different rules that sort of work as anti-subrogation rules. So for example, in Indiana, they've got a bizarre rule that says the insurance company has to use its insured's own attorney if the insured files a personal injury lawsuit. So what that does is if we're pursuing subrogation, we can't really settle a subrogation claim until we know whether or not the insured files a personal injury lawsuit, which puts us in a pickle because we have to wait until the statute of limitations expires. And I think a lot of states will sort of do that as well. And then Indiana has other rules like diminishment of subrogation claims, which means if the insured can't make a full recovery or is comparatively at fault, then there's going to be a diminishment of the subrogation claim. So that's pretty much the way all states work with anti-subrogation laws. Anything else? All right, back to Ted.
Okay, so next question. So does your insured need to present a bodily injury claim to a tortfeasor before you can subrogate for MedPay benefits? Let's go around the horn for this one. I'll handle Ohio first. In Ohio, there's no requirement that your insurer presents the BI claim before you can subrogate for MedPay. However, as a matter of practice, you know, I try not to interfere with the insured's BI claim. You know, oftentimes will be consolidated with the bodily injury claim. But I don't want to be in a situation where I'm trying my claim for $1,000 or $5,000 in MedPay first, particularly if there's a liability dispute and they have the insured. You know, I don't want to be in a situation where I get any bad case law or bad, you know, res judicata against the insured's claim. So I'm just careful about that. But there is no formal requirement that the insured, if the insured doesn't pursue a claim at all, you're still free to pursue your claim for MedPay in Ohio. Anybody want to talk to Michigan?
Yeah, I can. This is actually mostly an inapplicable question in Michigan. Tiffany already touched on it, but MedPay isn't an available option for motor vehicle coverage. When we talk about subrogation actions in Michigan in general, there's no need for a BI claim to subrogate. And that's because subrogation actions really only can result from the three very specific situations that Tiffany already touched on a few questions prior. That's situations where there's an uninsured operator or an owner, situations where there's intentional acts, or out-of-state accidents.
Mike, what about Indiana and Kentucky?
So in Indiana, I touched on a little bit. Indiana is an at-fault state, so PIP benefits aren't applicable. You don't have to worry about it. So you're only looking at MedPay, and you lose the right. The insurance company loses the right to subrogate if and only if the insured pursues a personal injury claim. So if they don't pursue a personal injury claim, then you can file suit and go after the tortfeasor. So that, again, puts us in a dilemma. So we can't really settle those claims, and we don't even know if we're going to lose the right to pursue those claims really until the statute of limitations expires. And then if a personal injury lawsuit is filed, then usually we consolidate. And the key to dealing with that is to put everybody on notice. You have to put really the insured on notice, the insured's attorney on notice, the adverse carrier on notice, and you have to say, look, we're out here, don't ignore us or somebody's going to get in trouble. And that's really the key to that. In Kentucky's a PIP state, but in most PIP states, you can add optional MedPay coverage. So we do see sometimes where MedPay is added on top of PIP benefits, and sometimes, you know, there's a little bit of nuances and differences between your ability to recover those. And again, in Kentucky, this is a little unrelated, but it's bizarre. You're allowed to sue a tortfeasor in its individual capacity so long as they're uninsured. If they have insurance, you can't sue them. You have to sue the carrier. So what Kentucky did is they have their own little in-state intercompany arbitration forum that most of the insurance company to insurance company disputes get submitted to arbitration and gets resolved. So that's Kentucky and Indiana.
And Tiffany, do you want to speak to any of our other footprint states?
Yes, so I agree with Tom that if for some of our other states it may not be applicable. So for example, in New Jersey, which is one of our footprint states, there's no right for the MedPay recovery. So there's no direct right. So that's not necessarily applicable. With Illinois, obviously you can have MedPay recovery, you can have subrogation. So in Illinois, there's no specific provision that says that you have to, the insurer first has to present a BI claim. So you can subrogate whether they've presented the BI claim or not. In Pennsylvania, the same thing. There's no statute or case law that says that you have to the insurer first has to present a BI claim in order for you to be able to subrogate. So I touched a little bit in on the other states, but there's no specific provision in New Jersey, Pennsylvania, and Illinois.
So next, the $1 million question, or maybe it's the $3,000 to $5,000 question, depending on your expertise. But do you really need a medical expert in several cases, or can you just simply rely on the medical records at the time of trial? Who wants to hop on this one?
I can take this question because I can provide my favorite answer. And if you've ever spoken with an attorney, you have heard this answer before. It depends. It depends on specifically what is at issue in the case. In a more broad general sense, first we need to kind of think about what expert testimony is required for. We use expert testimony when we need a witness that can provide a professional opinion or establish a professional conclusion. Really, the purpose of the expert in those situations is to help a judge or a jury, whoever your trier of facts is in any given case, to understand potentially complex or technical issues in the case. When those types of issues don't exist, expert testimony obviously isn't necessary. Now, if we tie those general concepts back into this specific question about whether experts are required for subrogation claims, we'll have to start at our favorite answer. It depends. What's at issue in the case? If it's a straightforward case, say an uninsured action in Michigan, and all we need to do is establish what bills were paid and the amounts that were paid out, lay witness testimony from an adjuster authenticating our client's business records would suffice. On the other hand, if it's a more contested case that involves more complex issues, say the defense has raised an argument about whether the insured's injuries reasonably relate to the accident. Obviously, there's going to be questions of medical reasonableness in there that I certainly cannot testify to, and I wouldn't expect any person who isn't some form of doctor or other medical expert to testify to. In a case like that, in a situation like that, where we need that testimony that can speak to those highly complex issues, we would certainly need an expert to testify at trial.
Excuse me, I agree with you completely, Tom. I think what the subrogation professional should do is should be in contact with their counsel, right? So, because it is going to depend on the case, and a case that is, as Tom said, more complicated as it relates to issues of causation as far as the injuries, yes, you absolutely are going to need a medical professional to relate those injuries to the motor vehicle accident. And then you probably want to think about an expert where you have insured that treated maybe 5-6 years, or excuse me, not years, months after the motor vehicle accident. If you have an insured that treated 5 or 6 years, then we probably have another issue. But 5 or 6 months after the motor vehicle accident, you probably want to look into potentially having an expert too. It is going to depend upon how the case is handled in litigation. So as attorneys, we do have some tricks up our sleeves that we can utilize. We can utilize discovery to try to limit, exactly what is at issue. We may be able to file motions to be able to get things dispositively resolved. Sometimes, you may be able to just do, a deposition instead of having the doctor testify at trial. So there are things that we can utilize to try to minimize that. But your attorney will for sure let you know if you're in a situation where you actually need an expert to testify, and in this particular case, a medical expert to testify. When we have those situations, they can be costly. So you have to remember that the medical expert typically, even if it's the treating doctor, would have to be paid to look at the medical records, review those, excuse me, potentially have a consultation with you, and then probably have some sort of prep, and then the actual testifying. So we try to be mindful of that as far as costs are associated with our clients, and try to be mindful to not run up the bill, right? But if it's required, we'll absolutely let you know that in order for us to prevail or meet our burden, we would need an expert in that particular case. Other than that, we can use a custodian of records, as Tom alluded to.
That's basically the same way it is in Indiana and Kentucky and Ohio as well, and basically every other state. I look at it as if two insurance companies are fighting over who has to provide coverage, then you're really basically just allocating fault and liability. And you don't necessarily need a medical doctor to say that coverage should have paid for those benefits. But whenever you're suing an individual tortfeasor, then you have to look at whether, the injuries are objective or discernible. If somebody breaks an arm and goes to the hospital immediately after an accident, you may not need a medical expert to say, that those treatments are reasonable and necessary. But, if somebody's had 5 motor vehicle accidents in the past and then a couple months later starts saying, oh, my neck hurts, well, you're almost inevitably going to need medical expert opinion to establish the reasonableness and causation of those injuries.
Very good. What are the most common defenses to MedPay and PIP subrogation claims? Tiffany?
Yeah, I'll jump in here. So traditional defenses always apply. So obviously you would need to demonstrate negligence in fault states. In no fault states, you would have to make sure you have met the requirements to be able to have that subrogation right. So with actual negligence stage, you have to show your duty, your causation, your damages, obviously your breach of that duty. In PIP states, I'll take Michigan, for example, in order for us to pursue an individual, let's say a tortfeasor, we would need to show that that person was uninsured, and I alluded to this before, engaged in an intentional action, or the accident happened outside of Michigan. Now, what's different about Michigan is Michigan has a separate statute that allows PIP recovery against a uninsured owner or registrant of a vehicle. So in those situations, we only need to show that the defendant or claimant was the owner of an uninsured vehicle or a constructive owner of an uninsured vehicle, meaning they had access to the vehicle for more than 30 days, or they were a registrant of the vehicle. We would need to show that the vehicle itself was involved in the motor vehicle accident. There doesn't have to be contact, but there has to be some level of involvement. We do not have to show that they were at fault for the accident. So the insured can be 100% at fault for the accident, and you're still able to. And then we would obviously show that PIP benefits were paid out. So defenses would typically attack those areas. So whether it was reasonable for the PIP benefit to be paid, again, whether it was related to the motor vehicle accident, which I kind of discussed earlier, whether they were a true owner of the vehicle, if the vehicle was sold before the accident, or if we're trying to argue they're a constructive owner, were they truly a constructive owner? Did they have access to the vehicle for more than 30 days? And then in addition, some other defense, you may encounter whether you have ability to stand in the shoes of the insured. That's a little bit of a difficult defense, but I've seen defense attorneys make that defense to say that we don't have a legal right, and then you'll have to go into your analysis regarding how subrogation rights come about. So whether it's contractual or if it's by law, you have to go into that, but sometimes that's also a defense as well. And then sometimes, very few times, the defense is a very basic and simple one, that this debt has already been paid. So meaning that maybe they've already paid the insured directly, and maybe the insured did not report anything back to the insurance carrier. And lastly, I don't see this defense that often, but it really burns me, is when the right of subrogation is waived by the insured, and that's not necessarily conveyed to our clients. And then if it's not conveyed to our clients, we don't know that. So sometimes the insured settles a claim, they're excited, and they're going to get a big check, and they don't necessarily look at the language of the release. Even when they have counsel, they don't always look at the language in the release, and sometimes they waive the right to subrogation. So
that's the most frustrating part for me, when you're working on a file and you find out the insured signed a what? Yeah, kind of really. A lot of it's a very fact specific, depending on who had notice and when everything happened, but that is a huge problem. And the second one is when you dig down and you're going through the contract documents and there's a waiver of subrogation provision, and you're like, oh no.
Yeah,
Very frustrating.
we get everybody on notice, the adverse party's carrier, all the lawyers involved, right? So
yeah.
Early notice goes a long way. Just paper up the notice and send it to everybody.
Mm-hmm.
All right, everybody's favorite topic, the made whole doctrine. Mike, do you want to tell us a little bit about that?
Sure. Subrogation, again, is largely equitable in nature, and every state has some form of the made whole doctrine, whether they acknowledge it or not, and they all treat it very differently. But the idea is that the policyholder has to be made whole before the insurance company gets to take any money away from the insured's funds. So the insurance company doesn't get to reimburse itself for payments that it's already made. The idea is that, and that really applies whether there's coverage on the other side the adverse carrier limits, they run out and there's just not enough money to fully compensate the insured. Or, with regard to lien rights or subrogation, a lot of states will step in and impose rules that say, yeah, we're going to pay the insured first before the insurance company gets any money. So an example would be in Ohio by statute, the made whole doctrine says that if an injured party is not fully compensated, the subrogating insurer still has a right to subrogate, but the claim is diminished in the same proportion as the injured party's interest is diminished. In Indiana and Kentucky, they apply the made whole doctrine, but there are a million exceptions, and they say that that right can be waived by express and unambiguous language in the policy. The problem is that most of the policies that we see don't expressly and unambiguously enough waive that language. So there's always room for argument and wiggle room and negotiation. It is interesting, though, that there are all kinds of exceptions. So for what it's worth, I know we're a little off topic on this comment, but the made whole doctrine doesn't apply to health and disability insurance, at least in Indiana. So everything is so particularly fact specific that you really have to know what you're doing to be able to know and understand whether you have a right to recover or you should make that claim. Kentucky has a very weird rule. There's really, if the tortfeasor's liability limits are exhausted, then what happens is the no-fault lien is also automatically extinguished. So Kentucky says, look, if we're going to give priority to the insured to make a recovery before the carrier gets to recover. But then again, on the other hand, if there are liability limits sufficient to pay everybody, or a settlement agreement sort of silent and doesn't mention that, then the no-fault automobile carrier is entitled to reimbursement in full. So it's just an example that every state just kind of goes rogue and does their own thing. And then even in Indiana, what they'll do is even if it's not quite the made whole doctrine, there are other judicially imposed rules that sort of limit your ability to subrogate. So Indiana has a lien reduction statute, and it basically works like the made whole doctrine, but it basically says two things. It's going to reduce the subrogated carrier's interest because of comparative fault, of course, but also because of uncollectability. So if you run out of money and the insured can't collect, then the statute kicks in and says, well, we're gonna reduce the amount that you can recover for your subrogated carrier. So again, being in equity, there's different ways you can argue in every different direction, and every state seems to have some application of that made whole rule or made whole doctrine. Hope that helps.
Yeah, so in a previous life, I did a lot of healthcare subrogation. So the made whole doctrine and its cousin, the common fund doctrine, were sort of the bane of my existence. There's a lot of interesting arguments that can be made both ways on that. I think one aspect that's pretty interesting, though, is if you've got two carriers that are members of arbitration forums, and you bring your case through via ARB, and you get your award for your MedPay, and then you've got a BI attorney wanting to hold on to a global settlement and not pay, do the made whole arguments come into play there? My experience is, obviously it's all very fact specific, and I'm jaded. I don't think any injury attorneys ever admitted their client was made whole. And then the argument is, well, why don't you guys ever get what your clients deserve? But but in my experience, sometimes they're just looking for a little haircut so they can pad their fees. But that's just my jaded view on it. We do have a few questions that have come through the chat. I just noticed. I saw one that says it was mentioned that in Pennsylvania, the insured doesn't have to submit a BI claim first. I didn't think we could subrogate PIP and PA. Now, to the extent that you can answer this, Tiffani, I know you're not a Pennsylvania lawyer, but you did look at the laws before we got in here. Are you able to answer that?
Yes, so PIP benefits are recoverable in within 2 years from the tortfeasor, from one, the tortfeasors that are not required to carry PIP, or tortfeasors that are required to carry PIP and fail to do so. So in that limited circumstance, you have a subrogation right. In all other circumstances, that's correct, you would not. And when there, excuse me, I should say it also when there's a commercial vehicle involved, but there may be some exceptions to that. So there's no, I guess when I was answering the question, this may have made it a bit confusing, when I was answering the question regarding whether the insured had to present a BI claim first before you can engage in any subrogation, or really the question called for MedPay. The answer is there's no law that says they have to present that BI claim first, but it's kind of a little bit tricky, kind of like Michigan, because there are so many things that don't apply and you only have limited situations where you can actually subrogate. So there's no case law that's on point that's specifically to that question, but also there are times where you can have PIP recovery, but they're limited situations.
And then there's another question that says, well, what if the MedPay damages are $5,000, so an expert makes no business sense? Roll your dice with the medical records and creative counsel, question mark. So a couple things. So obviously you're probably talking about a situation here, I guess where maybe there's not insurance on the other side. If there is insurance, this is probably a time, at least in an at-fault state, where you're probably somewhat piggybacking off the BI claim. So they probably would have an expert. But if you're in a situation where you have a uninsured defendant, I think Mike has some thoughts on some creative ways to perhaps get the medical records in or get somebody qualified as an expert.
Sure. So, it is tricky when you're only dealing with $5,000 of MedPay, right? But one of the arguments that I like to make that the defense counsel really appreciate is that if you can settle that claim, then the medical records aren't coming into evidence at trial when the insured files a personal injury suit. So what you can do is you can say, look, let's settle right now, and then those records, they don't come into trial. And that's pretty powerful because defense counsel is all excited if they can sort of exclude certain evidence of injuries from coming into trial when they're trying to defend a personal injury action. So, then there are some other things you can do. I mean, Tiffani mentioned that, one of the things we can do is we can file summary judgment. One of the things we can make them, kind of shift the burden to the other side to say they're not reasonable. One of the things we can do is we can send, discovery requests for admission. We can say, admit that these records are reasonable and necessary and related to the injury. And if those get denied, then what we can do is we can shift fee shifting at that point, where we can say, okay, that's fine, but we're going to bill you for the cost of my time and my doctor's time to come in and prove that you're wrong. So sometimes the threat of paying $8,000 additional dollars for a $5,000 claim will really facilitate a settlement. The other thing we can do is sometimes it just doesn't make economic sense. Let's say you've got a borderline uncollectible claimant, right? The defendant is just putting up a minimal defense and argues that it's unrelated. Well, you don't want to throw good money after bad. You don't want to spend a lot of money to get that money. So there are some settlement options that you could enter into that would sort of trigger a full judgment in the event of a default on a payment plan, for example. Or, what I like to do is sometimes I'll bring in the medical adjuster. If the medical adjuster has properly papered up the file, this is don't rely on this, everybody out there, but I try to qualify that medical adjuster as a competent expert medical witness. And the standard is based on skill, education, experience, training, all of those factors, where the adjuster can say, look, this is what I do for a living. I evaluate medical claims day in and day out. I looked at this, and this, and it's my opinion, my professional opinion, that these bills were reasonable and necessary and related to this particular injury. Now, if the stakes were a lot higher, I wouldn't recommend trying that. If there's good defense counsel on the other side, I wouldn't recommend trying that. But sometimes, if you're only fighting over $5,000 and it's essentially small claims court, you're probably gonna at least have a chance at carrying your burden. And in those situations, I think it's worth taking a shot rather than just giving up the claim and walking away.
In that case, you'd have to have an actual someone from the medical unit and not just your local field adjuster, whoever, or your subrogation rep probably. So just to qualify that, yeah.
Right, and I just want to piggyback really quickly on what Mike said, and also relate it back to what Tom said. I think you can get creative when what's at issue is not causation. So it's not specifically related to whether the injuries are related to the motor vehicle accident. So let's say if that's not an issue, as Mike said, you can use the adjuster to not only testify as an potential quasi-expert, but also as an expert adjuster, because usually the adjuster is the one who looked at the medical records, made a determination, whatever determination they made, and then paid claims. So you can use that person to demonstrate that it was reasonable that the claim itself was paid. So kind of taking a shift off of the injuries itself, but more focusing on the payment. You are able to do those things when, again, the defense is not making a specific argument that the injury isn't related to the accident, or the treatment itself may be excessive. When you get into specific defenses related to the injury, you probably will need some sort of medical professional to testify to that, and usually the treating doctor is the best one. But if it's not specifically related, you can do a little bit of dancing. I have done dancing. I have used the adjuster to get in medical records under the guise of they adjusted the claim and they reviewed those documents, and that's what they relied upon to pay the claim. So absolutely, I've done that in trials before, but you just have to be careful and you have to know what's at issue.
Yeah, so we got another question in the chat here. Pertaining to Michigan, so that they've had some claims where the claimant vehicle was sold and the prior owner didn't ensure that the vehicle was registered to the new owner, who's now at fault for the loss. Leaving the prior owner considered responsible for the PIP payments. Would the prior owner be responsible without proof the vehicle was sold?
Depends. No. So the law in Michigan is that owner of a vehicle is, when they're transferring title, they're required to do one of two things: either physically go to the Secretary of State, that's what our DMV is called in Michigan, the Secretary of State, and have the actual title transferred over at the time of that purchase. That's one requirement. Usually people do not do that. You usually sell your vehicle, especially if you're not selling it to a dealer. You just sell it and you hope and give them the title when you walk away and you're completely done with it, and take your insurance off and driving your new vehicle. The other requirement is for you to keep the bill of sale for 18 months. So what if we're within 18 months of the sale, we're fine. If they don't have the bill of sale, then we can file an SD. They didn't comply with Michigan law. But that's usually not the situation. Usually we are outside the 18 months. Now, the difficulty, or I guess the dance in this, is that if the defendant has an attorney who knows that, and we're outside the 18 months, they'll make an argument that they complied with the law by keeping the title for 18 months, but we're outside of that point. They weren't required to keep it anymore. They destroyed it or whatever they did. Some judges will buy that argument. Some will say, no, I still want the bill of sale. I still want to see it to see that the vehicle itself was transferred. But sometimes defendants don't know to make that argument. And if they don't know to make that argument, then we fall back to, we need the bill of sale to show that the vehicle was actually transferred. So if you cannot prove that sale itself, then that previous owner is still legally the owner, and they will be obligated to pay PIP benefits regardless of fault.
Kentucky's a similar state. It's a pure registration state, and if you don't transfer title, then you're still responsible. So we love suing owners because the owners are the people that have the money. So that's definitely something that I would encourage everyone to check in every state to see if you can pursue the owner. We do that frequently in Kentucky.
So I'm going to kind of move quickly through our last couple of slides here because we're getting close to an hour and I don't want to run over, and I know Tom's got to run to court. So can I inadvertently waive my insured's rights to recovery when settling a subrogation claim, and what language should I avoid in the subrogation release? The short answer is yes, you could. This is why we have lawyers. And I would recommend that you run it either by your subrogation lawyer, your in-house counsel. Does anybody have anything real quick to add to that? That was just my quick answer to that. Yes, you can.
Yes, just avoid indemnity language, waiving all rights for everybody in the world. Just avoid any language like that, but absolutely get advice of counsel.
Yeah, I think the biggest problem is assuming ongoing obligations. So, whenever you're doing a release, insurance companies can represent that they own the claim, that they're properly releasing the claim, that they properly paid the claim. But anytime there's an ongoing obligation that will live past the date of the release, that's problematic. And that includes a duty to indemnify, or a duty to defend, or a duty to hold harmless, or whenever the scope of that duty expands beyond the date of the release, that's really when you get yourself in trouble.
And the ninth question was just about statute of limitations. For Ohio, it's the same 2-year. For BI, applies to MedPay. What about Indiana and Kentucky, Mike?
Indiana's 2 years. Kentucky is Kentucky's weird. Again, Kentucky's basically 1 year. If it's a motor vehicle accident, it's 2 years. And Kentucky will extend the statute of limitations if there's a PIP payment. So it's 2 years from the date of the last PIP payment. But the exception to the exception to the exception is that MedPay payments do not extend the statute of limitations. So you have to really understand whether it's a PIP payment or a MedPay payment, and sometimes we see both, and then you'll have basically 2 years.
Just out quickly, Illinois is 2 years, Pennsylvania 2 years. The personal injury statute of limitations is 2 years. And then New Jersey, there's a requirement to submit your arbitration demand within 2 years. And then again, we already kind of discussed the exceptions and things, but then there's a 2-year statute of limitations.
But the caveat is that I have much better luck pursuing claims and settling claims if it's quick. So I like to get right in there, pursue that money, and get paid within 60 or 90 days after the accident. I mean, if we're pushing a deadline, then all the evidence goes stale, memories fade, it just becomes more difficult, everything gets more contested, and when the accident's sort of fresh, that's when we have our best luck. We also identify the responsible parties early, and we just have better luck.
Tom, what about Michigan?
Oh, okay, I was gonna say maybe answer Michigan because I think Tom probably has
to run.
Yes, good luck.
Thank you, I appreciate that. Real quick, in Michigan, for traditional subrogation actions that are rooted in negligence claims, that's going to be a 3-year statute. The little difference in Michigan is that subrogation actions against uninsured owners or registrants, when we're seeking to recover solely PIP benefits, there's a 6-year statute of limitations for those claims.
Great.
And then suing in different jurisdictions and borrowing statutes and which statute applies is always a mess. It's the safest bet to go with the earliest one.
So the final kind of catch-all question: most common pitfalls handling subrogation cases involving PIP and MedPay, and how can I assist in avoiding them? Tiffany, you want to take this one? Or
yes, I can. So just I'll just be very brief. You know, you want to make sure that you have your proper documentation for your claims file. You want to make sure that you have you review what the underlying adjuster actually did in relationship to what still needs to be done to show causation, to show that the relatedness of the damages and things like that. And I see that we are running up on, well, it's actually noon at this moment, so I'm going to do a pitch. We are going to go in more detail regarding this topic and many more at the upcoming conference, the National Association of Subrogation Professionals. It is October 28th, I believe it is. Actually, add that up. October. Yes, October 28th to October 30th. So we hope that you all can join Mike and I, in addition to an adjuster from Nationwide, will be presenting the topic of do not leave money on the table. So we hope that you can come and attend the conference and also listen to our presentation. Ted has been kind enough to put up our contact information. So obviously, if you have any more questions, we could talk about MedPay and PIP all day, as I said in the beginning. So please feel free to reach out to us. We haven't covered everything in detail. It's much more that we all wanted to say, but we didn't get opportunity to. So please feel free to reach out to us. And then one more pitch. Tom is actually is going to present a blog on PIP as it relates to Michigan. So it'll be more expansive, discussing the laws as it relates to PIP and your rights and recoveries. So look out for that in conjunction with the blog regarding a summary of our webinar today. And I'll turn it back over to Ted.
Yeah, just wrap up real quick. Thanks for everybody's time. I appreciate it. I know it's getting to be lunch hour and tummies are grumbling. Mine is anyway. So we hope you liked it. You'll get a short survey. Please fill it out. Please provide some suggestions for future webinars. We do have a library of webinars that you can check into. But thanks again for attending. Have a great weekend, great rest of your day. Thank you.
Bye-bye. Take care, everyone.
Bye.
Thank you, everyone.